Have you ever found yourself staring at some dense legal document, maybe feeling a bit overwhelmed, like you need a secret decoder ring just to figure out the first paragraph?
Yeah, happens all the time. Legal language can be pretty opaque.
Exactly. We've all been there, especially with laws that, really affect our daily lives and society. So today, we're tackling one of those cornerstones, the Drugs and Drug Trafficking Act 140 of 1992.
A really significant piece of legislation.
Definitely. It's complex, it has far-reaching implications, touching on everything from, say, personal use right up to international trafficking. Okay, so let's try to unpack this a bit. Our mission for this deep dive is really to demystify this act for you.
Okay.
Whether you're just a curious citizen wanting to understand your rights and obligations, or maybe you're a law student wrestling with all the details, our goal is to break down its purpose, its key rules, and importantly, its real-world impact. We want to make it clear, engaging, and, well, digestible.
A shortcut through the jargon.
Think of it that way, yeah. Your shortcut to understanding this vital area of law.
And what's really interesting here, I think, is that we're not just looking at some dusty old document frozen in 1992.
Right.
Our main source is a consolidated version of the Act, updated right up to, I believe, October 2024. So it shows how the law lives and breathes.
That's a great point.
And by looking at its history, all the amendments it's gone through, and especially how the courts have interpreted it, well, that gives us a fascinating glimpse into how laws adapt,
Yeah.
how they respond to constitutional rights and changing societal views. It really shows the dynamic nature of law.
So to really get a handle on its impact, maybe we should start at the beginning.
Right.
When it first came into effect, back on April 30th, 1993, what was the problem it was trying to solve? Was it something completely new or more about pulling existing things together?
Well, the Act's own long title actually gives a pretty good roadmap of its purpose. It's quite broad. It says it's to provide for the prohibition of the use or possession of or the dealing in drugs, for the obligation to report certain information to the police, for the exercise of the powers of entry, search, seizure, and detention, for the recovery of the proceeds of drug trafficking, and for matters connected therewith.
Wow, okay, so that covers a lot of ground.
It really does. It tells you straight away it's much more than just targeting individual users. It's designed as a comprehensive framework. It aims to regulate, well, a whole spectrum of activities.
Like what specifically?
Everything from simple consumption right through to complex supply chains, making precursor chemicals, and even the money side, acquiring or converting proceeds from drug crimes.
And how does it fit with other laws, like the Medicines Act?
Good question. It's crucial to understand that this act works in addition to, not instead of, the Medicines and Related Substances Control Act of 1965.
So like 2 layers of rules.
Exactly. A dual-layered regulatory framework. It aims for a pretty tight grip on these substances.
That makes sense. Okay, so before we dive into the specific things the Act prohibits, maybe we should clarify some key terms. Legal language can be so precise, right? Understanding these definitions in Chapter I feels like getting the foundations right.
Absolutely critical. Those definitions, they're the bedrock. If you misunderstand them, the whole picture can get distorted. So first off, drug itself isn't just one thing here.
Right.
The Act actually splits it into categories. Dependence-producing, dangerous dependence-producing, and undesirable dependence-producing substances.
And where do you find those?
They're all listed out in Schedule 2 of the Act. And which category a substance falls into, well, that directly impacts how serious the offense is and what the penalties might be.
Okay. What about deal in? That sounds like just selling, but I suspect it's more complicated.
You suspect right. It's much, much broader than just selling. The Act defines it explicitly to include things like transshipment, importation, cultivation, collection, manufacture, supply, prescription, administration, sale, transmission, or exportation of a drug.
Whoa. So even just growing a plant, if it's listed as a drug here, could potentially count as dealing in it.
Potentially, yes, under the strict definition.
But hang on, even a foundational law like this can change, right? And one of the biggest shifts, I imagine, has been around cannabis, or DIGA. For ages, it was strictly banned under this act, but then there was that huge legal development in 2018.
You're absolutely right. That wasn't just a minor tweak. It was more like a constitutional earthquake.
Yeah.
The Constitutional Court, in that landmark Prince case, Minister of Justice and Constitutional Development, and others, v. Prince,
Yeah, I remember the headlines.
they declared parts of this very act invalid. And the reason? Because those parts criminalize the private use, possession, or cultivation of cannabis by an adult for their own personal consumption.
So it fundamentally shifted the balance between state control and individual privacy.
Exactly. It redefined that balance concerning what happens in your own home. The court issued what's called a reading-in order.
How does that work? We're reading in.
Well, think of it like the court saying, okay, Parliament needs to update the law formally, but until they do, everyone must read the definition of deal in Section 1 and the prohibitions in Section 4B and 5B as if they already exclude cultivating cannabis by an adult in private for their personal use in private.
So it modifies the law immediately based on the Constitution.
Precisely. It's a powerful judicial tool. And Parliament has actually followed up since then with the Cannabis for Private Purposes Act of 2024. Once that comes into effect, it'll formally write the court's judgment into law, aligning things properly with constitutional rights.
Okay, that's a crucial piece of context, especially with cannabis. So with those terms clear and that evolving landscape, let's zero in on what the Act actually forbids. What are the main illegal acts listed in Chapter 2?
Right. Chapter 2 lays out the core prohibitions. Section 3, for example, it stops anyone from manufacturing scheduled substances or supplying them if they know or even suspect that substance is going to be used to unlawfully make drugs.
And these scheduled substances, they're like ingredients.
Essentially, yes. The listed in Schedule 1, basically precursors for making illegal drugs. So it targets the very start of the supply chain.
Makes sense. What else?
Then you have Section 4. This is the broad prohibition on using or possessing any of those categories of drugs we mentioned, dependence-producing, dangerous dependence-producing, or undesirable dependence-producing.
But are there exceptions? Like for medicine?
Yes, and this is really important for people to know. There are lawful exceptions. It is okay if you're a patient, you have a valid prescription from a proper medical professional, doctor, dentist, vet, pharmacist, and you got the substance for medicinal purposes.
But not just to feed a habit.
The Act explicitly excludes using it just to satisfy a habit or craving. And of course, like we just discussed, the Prince judgment carved out that exception for adults using or possessing cannabis privately for personal use. That's no longer a criminal offense under this section.
Okay. And then Section 5.
Section 5 prohibits dealing in any of these substances, and this is where that really wide definition of deal in, importation, cultivation, supply, etc. really kicks in.
With similar exceptions for professionals.
Exactly. Again, there are exceptions for medical and pharmaceutical professionals who are acting properly within the scope of the Medicines Act, prescribing, administering, supplying for legitimate medical needs. And just like Section 4, the Prince judgment also modified this section regarding cannabis excluding private cultivation by an adult for personal use.
Okay, so the Act clearly lays down the rules, but rules need enforcing. This next part, Chapter 3, sounds like where the state's power really comes into play, and maybe where courts sometimes step in. Who enforces these rules and what powers do they actually have?
You're right. Chapter 3 deals with enforcement reporting obligations and police powers. First, it defines designated officers. These are specific commissioned officers in the South African Police Service assigned to the South African Narcotics Bureau. They're the specialists for this law.
Got it. And what about reporting? Do ordinary citizens or businesses have obligations?
Yes, Section 10 lays out an obligation to report certain information to police, and it's quite broad. For instance, if you own or manage a place of entertainment, which could be anything from a club to a vehicle used for parties, and you suspect drug activity,
You have to report it.
you're obligated to report to the police as soon as you can and provide any details you have.
Interesting. Anyone else?
Yes, stockbrokers and financial instrument traders too. If they suspect in their ordinary business that some property they've acquired is actually the proceeds of a defined crime, they also have to report that suspicion to a designated officer.
So it links drug crime to financial crime.
Absolutely. And what's really crucial here is that these reporting duties override any other laws or even agreements about secrecy or confidentiality. The message is clear. Fighting drug trafficking takes priority.
Okay, moving from obligations to powers. This is where it can get controversial sometimes, right? Police powers versus individual rights. How does the Act empower the police?
Well, Section 11 historically granted police officials pretty broad powers. It allowed them, if they had reasonable grounds to suspect an offense, to do things like enter and search premises, vehicles, people, search containers, intercept mail, question people, demand documents, and seize anything connected to an offense under the Act.
That sounds like a lot of power.
It is. But here's where the judiciary, again, played a crucial role as a check. In that 2016 case, Minister of Police and others v. Kunjama.
The one you mentioned earlier.
That's the one. The Constitutional Court found parts of Section 11 specifically related to warrantless searches and seizures based only on reasonable suspicion to be unconstitutional and invalid.
So they can't just search without a warrant based on suspicion alone anymore.
Not in the same way, no. It was a massive decision reinforcing the need for judicial oversight, usually a warrant, before the state can invade someone's privacy like that. It strongly protects our constitutional right to privacy against potential state overreach. So police still have powers, but Kunjana means warrants are often required now.
That's a really important balance. Anything else on enforcement powers?
Well, Chapter 3 also includes Section 12, which deals with the interrogation of persons under warrant of apprehension. A magistrate can issue a warrant to detain someone if there's reason to believe they're withholding information about a drug offense.
Sounds serious. Are there safeguards?
Yes, very important ones. The person must be brought before a magistrate within 48 hours and then at least every 10 days. They have the right to a lawyer, and they must be examined and regularly visited in private by a district surgeon. These are critical procedural protections for detainees.
Okay, so the Act defines what's illegal, outlines how it's enforced. But what happens if you actually break these rules? What are the legal consequences we're talking about for someone caught on the wrong side of this law?
Right. Chapter 4 covers all that. Offenses, penalties, presumptions, and forfeiture. Sections 13 through 16 outline the various offenses, everything from making those scheduled substances we talked about to obstructing the police or just failing to report information when you're supposed to.
And the penalties. Are they severe?
Section 17 lays them out, and yes, they can be quite severe. They vary a lot depending on the specific crime. For example, just obstructing a police official could mean a fine or up to 12 months in jail.
Okay. What about drug possession or dealing?
For using or possessing dependence-producing substances, it could be a fine or up to 5 years. If you're caught dealing in those same substances, it jumps to potentially 10 years.
And for the dangerous or undesirable ones?
That's where it gets really serious. Dealing in dangerous dependence-producing or undesirable dependence-producing substances, which, remember, used to include cannabis before Prince, carries a maximum sentence of up to 25 years imprisonment.
25 years, wow. That really shows how differently the law treats different offenses and substances.
Absolutely. The distinction is significant.
Now, let's touch on something you mentioned, presumptions. That's always a fascinating, sometimes tricky part of criminal law, isn't it? They can kind of shift the burden of proof.
They can indeed. A legal presumption basically means a fact is assumed to be true unless someone proves it's not. So the law might say, if we prove fact A, we'll assume fact B is also true unless you, the accused, can show B isn't true. It can flip the usual burden.
Does this act use presumptions like that?
Yes, it does, or at least it did historically. For example, Section 19(2) says if you're found with more drugs than you could have legally gotten for medicinal use with a prescription, it's presumed you were dealing in them until you prove otherwise. The aim is clearly to target trafficking.
But I sense a but coming. Have these presumptions held up in court?
That's the crucial point. Several key presumptions in this act have actually been struck down by the courts as unconstitutional.
Why is that?
It comes down to that fundamental tension. The state wanting efficient prosecution versus the individual's absolute right to be presumed innocent until proven guilty. The Constitutional Court has consistently said that right is paramount.
Can you give an example?
Sure. There used to be a Section 20 that said if drugs were found in your immediate vicinity, you were presumed to possess them. That was declared invalid back in 1998 in the S.V. Mello case.
All right.
Similarly, there was a Section 21(1)(c), which presumed you were dealing if you were simply found conveying any drug. That was struck down in S.V. Meniono in 1999. The courts are very protective of the presumption of innocence.
That's incredibly important context. What about businesses? Can a company be liable if an employee commits an offense?
Yes, Section 24 deals with the liability of employers and principals. An employer can be held liable for their employee's offense unless they can prove 3 things. 1, they didn't permit the act. 2, they took all reasonable steps to prevent it. And 3, the act wasn't actually part of the employee's job description or duties. It puts a significant onus on employers.
Right. So beyond fines and jail time, the act also goes after the assets, the money involved in these crimes.
Absolutely. It aims to hit offenders where it hurts their pockets. Sections 25, 26, and 27 deal specifically with forfeiture.
What does that mean in practice?
When someone is convicted of an offense under this act, the court must declare certain things forfeited to the state. This includes the drugs themselves, any scheduled substances, but also property used in the crime, vehicles, equipment, even immovable property, like a house if it was used in or connected to the offense or found in the convicted person's possession.
That could be devastating. What if someone innocent owns that property? Like a spouse or a bank holding a mortgage?
Ah, good point. The Act does build in protections for innocent third parties. If someone has a legitimate interest in the forfeited item, say, they co-own the house but had no idea about the crime and couldn't prevent it, they can apply to the court.
To get their share back.
Exactly, to protect their interest. Or, if the state has already sold the property, they might even be able to seek compensation. It's a crucial fairness mechanism to ensure innocent people aren't unfairly penalized.
Okay, so this act was signed way back in 1992. It clearly hasn't just sat there unchanged. How has it adapted over, 3 decades now of democratic South Africa, shaped by new laws, those constitutional challenges?
It's definitely been a living document. It's undergone numerous amendments through other major laws, things like the Justice Laws Rationalization Act, the International Cooperation in Criminal Matters Act, the Proceeds of Crime Act, and significantly, the Prevention of Organized Crime Act, POCA.
So it's constantly being updated or interacted with new legislation?
Precisely. And interestingly, many sections that originally dealt with the proceeds of crime were actually repealed from this Drugs Act.
Why was that? Moved somewhere else?
Exactly. Those aspects were largely consolidated into newer, more specialized laws like POCA. It shows how the legal system evolves, it streamlines things, moving certain complex areas into more focused legislative frameworks.
Is there anything else about its structure or how it operates that's worth noting?
One final point in Chapter 7 is Section 64. It deals with the jurisdiction of magistrates' courts. It specifically allows these lower courts to impose any penalty mentioned back in Section 17, even if that penalty, like a 15 or 20-year sentence, goes way beyond the normal maximum sentences or fines they're usually allowed to hand down.
So it gives magistrates' courts extra power for these specific offenses.
Yes. It really underscores how seriously the legal system treats drug offenses, allowing even lower courts to impose significant sentences when the case warrants it, which helps ensure swifter justice.
Right. So after all that, what does this deep dive really mean for you, the listener? We've journeyed through this pretty complex landscape of the Drugs and Drug Trafficking Act of 1992. We've looked at its core definitions, the things it prohibits, the enforcement powers, and crucially, those big constitutional challenges like prints on cannabis and kunjana on searches.
And I think what this really highlights is how one single law isn't static. It's constantly interacting with bigger legal ideas, with public policy, with changing social values.
Right.
It's this really complex dance between prohibition, trying to protect individual rights, and the ongoing fight against very serious crime. It keeps adapting. It's not just a list of rules. It really reflects an evolving society and its priorities.
So whether you're that law student trying to get your head around legal interpretation, or maybe just a citizen wanting to better understand your rights and what's expected of you, we really hope this deep dive has given you a clearer, maybe more nuanced picture of this vital area of law.
Hopefully you feel you've got a stronger grasp now of its purpose, its key rules, the legal context around it, and how it actually plays out in the real world.
Definitely.
And maybe this leaves us with a final thought for you to chew on. As societies everywhere continue to debate drug policies, individual freedoms, conversations about medicinal use, decriminalization, they're happening globally. How might acts like this one continue to evolve? What new challenges, what new considerations will shape their future? What kind of balance will societies ultimately decide to strike?